Yeah, so much of our life, so much of our lives are dictated by politics, politician. I mean, it's really only a handful of world leaders and organizations that are dictating a lot of our lives, a very, very small fraction of people actually compared to the rest of the whole, which is us. And that's why I think it's always important that we realize as people that together we have a much bigger voice. We have much more power than we actually think, just because of how the numbers are slighted. There's billions of us.
Oh, yeah. Yeah. The people have the power. We are, the ones driving the economy, working, spending. But at the same time, I feel like we get the short end of the stick. In a lot of countries, not just the U.S., a lot of these, what used to be attainable of buying a house and starting a family, it just seems economically unviable for a lot of the younger generations.
Yep. Agreed. Well, welcome back, everybody, to Break the Cypher.
Yeah.
It's good to see you. Thanks for jiving with us a little bit on the news. We are here with you for episode 6. The unanswered court. All right. And so, we hope you've had a great couple weeks away. We've certainly missed you. It's been pretty good for me. Has it been pretty good for you?
Yeah. Things are cruising along.
Nice.
Yeah.
I'm kind of tired, a little stressy. It's a fine line between anxiety and excitement for me right now. It's day to day. But I'm keeping my head up, keeping a positive attitude about it, and, just kind of basking in the uncertainty of the whole situation, and it kind of became an exciting thing for me to think about just how exciting uncertainty can be and how much progress can come from uncertainty, because I definitely feel motivated. I feel like there's a friction and a fire alive inside of me, and that is coming from the uncertainty. That's coming from change and discomfort and all these things that you would associate to being negative. But I'm turning it into a positive thing for me as I roll forward. So, I'm feeling it. I'm feeling good.
That's important. I'm glad to hear that. Yeah. Uncertainty kind of, it can go both ways, It's a scary thing in some regards, but it's also opens up a lot of opportunities to shape it how you see fit. So, we're picking up with the story here. This is where you'd expect someone or anyone to respond: a court, a clerk, a licensing board, maybe even, hey, we got your email. That's the nice thing about iPhone. Sometimes it's like, oh, okay, read. But can we get a response?
Mm-hmm. Right. I mean, all these people are paid on taxpayer dollars, and we're getting crickets, silence. It's like the town of Telluride locked their inbox and threw away the key. See you later. It's pretty funny.
Yeah, it's unfortunate, but the kicker is that Alpine's filed motions. Alpine's filed objections. And they've also sent Cora requests. And all Alpine has received is now, out of the blue, a sizable bill for how much that information would cost them.
Mm-hmm.
What?
Yeah, which is a lot of information that was requested by the court. Town of Telluride was supposed to provide the administrative record to the court months ago at this point, and they haven't. So sending a Cora request into the town is something that anybody can do. Because everything that happens on behalf of the town is public information. It's your tax dollars paying for it. You have a right to the information. Alpine goes in, tries to get the information, and it's going to be $600 plus it's likely to increase at a rate of $40 an hour across 5 different people working on it. And you can't get the information without first paying for it and agreeing to the increase. And it's like, wow, I've already had to open up a court case, which costs money. It's like $300 to start a case. The court already asked you for the information, and you've ignored it. And so, let's go back to August 13th real quick. That was the last time Telluride scheduled a hearing against Alpine Wellness. But Alpine didn't attend, and for good reasons. It's a process they've been saying over and over again is invalid, and showing up to a process that you say is invalid kind of validates it, especially when you're dealing with government agencies that won't follow their own code, that won't treat you with your constitutional rights, that won't respond to the court. It's like, hey, this is all BS.
Yeah. You can't validate a process like that because it's already proven itself invalid by the actions they've taken. And so the town now has refused to rule on multiple motions. They've refused to produce the administrative record, which is literally required for court review. I mean, it's just appalling. Even when you were talking about the court request and how there's a paywall associated with that, it just seems like, isn't that what taxpayer money is used for? Why would there be a paywall to deter people from getting public information?
Yeah. And I mean, you're literally charging a company for the people, the very people's time that created the issue. We're talking about the hearing officer, the clerk, the town attorney, the assistant attorney, these are the people who created the problem. Now the company, Alpine, is going to have to pay these people to work on providing the record of mishaps that they created. Like, that is just bonkers to me. And so instead of walking into another kangaroo hearing, Alpine sent a formal notice of non-attendance, then filed a motion to compel in district court a week later, requesting sanctions if the town didn't respond. And it demands that the town submit the full record and asks the judge to sanction them for the obstruction, as I said. And so that is the part that we've kind of left off on as far as where this has gone after the hearing and the court. So,
yeah, and since then, there's been nothing. There's no ruling, no response from the town of Telluride. They've gone full ghost protocol, radio silence. I mean, at least do something in Morse code, I don't know. There's got to be some sort of communications, but no, nothing. Nothing has really come about of it. So it leaves us in an interesting predicament. But some new developments that could be very, very groundbreaking to this case and others.
Mm-hmm. Yeah, I mean, I think it's important. I think it's important for people to realize that they can stand up, they can push back. It might be uncomfortable, it might be uncertain, but yeah, a little more on this Cora request thing. So that's August 20th. Alpine filed a Cora request, Colorado Open Records Law, asking for internal communication about hearing officer Lieberman disappearing from the town's website, internal email chains discussing Alpine's case, and any discussion about Alpine's filings between these parties outside of a public hearing. Because, when it comes to the hearing officer, when it comes to the lawyers, like, the lawyers are the prosecutors, the hearing officer is the neutral judge, and Alpine is the defendant, right? And so if there's any collusion going on in areas that the public can't hear or see, or behind closed doors, those are all things that are not allowed by law. And so, yeah, it was really interesting. The hearing officer, his information from the town's website became completely inaccessible. I believe this is the hearing officer for alcohol, tobacco, and marijuana in Telluride. And days after the hearing, I'm getting a call from the newspaper about how the information has just disappeared. Isn't that wild? And the comment that was made was, it was like, oh, the information was just there the other day. I'm trying to get a hold of him so I can get a comment, so I can ask a couple questions, somebody doing journalism, and nowhere to be found. Can't find the information. Gone. I don't see anywhere in the public record where that was talked about. But seemingly he's just disappeared. So that's pretty interesting.
Yeah, another twist and turn to the ongoing case. And so finally, the town responds to any correspondence coming from Alpine, a response to a core request. Until then, they were just ghosting. But the town attorney, the town clerk, nothing. And a lot of this information that should have been submitted to the court before the deadline of July 7th. So they're missing their own deadlines with this non-correspondence, non-communication. And the fact that people are just disappearing off the face of the website, off the face of the earth, can't get in communication. It's super telling that what's going on behind the scenes. Like, yeah, obviously something. If you got to delete people from a website, like, why did you do that?
Yeah, why did you do that? And why, this actually involves somebody that has been a big part of the rights being violated. The hearing officer has been a huge part of that. And so the fact that he's just AWOL, can't find him, can't question him, can't get a response from the town, he is a major contributor to the actual problem, just disappears. And so anyways, it's not just that they're not answering the court now. It's Alpine has been forced to go out and try and get the information in a different way because the town has refused to submit to the court. And the court request is a hefty bill, as we explained, $600 to complete the request. And then it's subject to $40 an hour, right? A financial stonewalling after the business was compelled under duress to close its doors after the record had already been requested by the court. And so, money's hard to come by. Right. It's not an easy time to come by money. And the information that's being requested has been requested over and over and over again for months. Wild. And so, let's talk about the hearing minutes from May and July now, because this was another important part. The hearing minutes exist on Telluride's website. If you're interested, you can go look for them. I believe the hearings were May 29th and July 29th with the Marijuana Licensing Authority. The minutes are on there, and they're extremely vague. Okay. So Alpine filed formal objections to the meeting minutes. Neither sets of meeting minutes went through for formal approval procedures within the hearings. Was there talk about approving the minutes? Yeah. But was there a moment for everybody in the room to say, no, I object to the meeting minutes? No. Happens very quickly. And Alpine does object to the minutes. It pointed out the omissions. The town literally erased every objection, every constitutional conflict that Alpine brought up from the record, like Alpine never spoke. The meeting minutes are vague, and that's why we're really happy that the recordings exist. But the meeting minutes were incorrect. They were objected to. Alpine got zero response.
Yeah, that's an extreme redaction. So basically, Telluride's official version of those meeting minutes that is public record on the website, it reads like a bad Wikipedia edit. Like, it's just totally sanitized, redacted. It's whitewashed. It's like a CIA document with all this like black, permanent marker redaction, except there's no like actual permanent black marker redaction. They just deleted it completely. And so there's not much information at all. And it really questions the accuracy of those meeting minutes because like the recordings have every word that was spoken, they're true to a T. And I feel like the meeting minutes should reflect that. But instead, they're kind of taking their own liberties with what was said during the meeting.
And it's extremely vague. And again, the town never acknowledged the objections. Like Alpine said, hey, I object to the meeting minutes for May 29th and for July 29th. They never corrected the minutes. They never said a word about them, And so, that's like the meeting minutes are important. They're a part of the administrative record. They don't reflect anything Alpine was saying. They're very vague. And there was never a real opportunity for the room to vote on accepting the meeting minutes, which should involve all parties involved agreeing to the meeting minutes. That's how it works on a municipal level, usually. But let's zoom out, because it's not just Telluride. Alpine filed sales tax protests with the Colorado Department of Revenue back in May.
So Alpine filed for these requests and paid partial taxes under protest. Under state law, CRS 39-21-104. And that's what Alpine is supposed to do. They're following the law. They're paying their partial taxes, but it's under protest.
Mm-hmm. And again, silence. No ruling, no call, no acknowledgement. The Taxpayer Advocate's Office has still not responded, except for confirming receipt of the protests and letting us know they'll get back to us. Now, these protests have a lot to do with, like, hey, there's a local municipality that is overreaching, operating outside of their jurisdiction, violating their own code, violating the Constitution in Colorado, violating the U.S. Constitution. There is a heavy paper trail of Alpine trying to get the state involved so they can come in and say, hey, Telluride, you really can't be asking that question. And we already know through the experience with Norwood, because Norwood removed the language from the application after calling the state, and the state said, no, that is not required by the law. So the fact that the state has just decided to turn the other direction and ignore it and neglect the situation, not offer equal protection in the state of Colorado, it's a big deal, because now they're a party to this. Now they are a part of this that could have resolved the problem, but they chose to ignore it. And so now they are a part of creating the problem. And so, yeah, we're still waiting to hear about that. And hopefully we hear something soon. Hopefully we can request a hearing with the Department of Revenue, because we're really interested in what they have to say. They are, all these municipalities and state agencies, they're collecting money. They're making money off of cannabis. They're licensing cannabis businesses. They're taking taxpayer dollars. They're doing something with it. We don't always know what that is, but I do know right now it hasn't afforded me any sort of protection. And big motto of ours is no taxation without representation. And it's like, if this is just about sending you guys money and you're not gonna support us, you're actually going to take a situation that's gotten out of control and say it doesn't matter. Well, you had responsibility to act. And so that's where we're at with the state. So still working on that, still hoping to hear something from them. And I would have expected to by now. If the state reaches out to you and you don't respond to them,
you're on a list.
Guess what? Yeah. But the feeling's not mutual.
No. I mean, I can only imagine the frustration. I mean, it seems like everywhere you're going to for requests of information, communication, anything like that, there's just been no correspondence, no cooperation to even, the tiniest degree of a response. And so, it puts Alpine in a very interesting situation where they're standing up for their rights. And if the other parties involved aren't going to follow due process, if aren't going to follow their own rules and regulations, then they should be penalized, and they need to, take ownership of that. And so that's why Alpine Wellness, and that's why Break the Cypher here, we're standing up for the cause of not only marijuana businesses, but for all businesses, for all people, for rights, for constitutional rights. It's important. And that's where it gets really interesting. It really brings us to the Supreme Court recently just overturned something called the Chevron Deference. And if you've never heard of it, you're not alone. It's something that has just recently changed, but it's been decades in the process.
Yeah, so let's break it down a little bit. For the last 40 years, if a government agency said a law was ambiguous, they were the ones that got to interpret it however they wanted. And courts would usually defer to that interpretation. And so, in a nutshell, a state agency like the Marijuana Enforcement Division, the Department of Revenue, let's say the Marijuana Licensing Authority in Telluride, the DEA, the FDA, the IRS, if they had these regulations that they made, and they made these codes and these statutes and these policies, and any of that was ambiguous, a court would usually leave it up to those agencies to interpret the code. But in June of 2024, that was overturned. I mean, that is how the world existed for 40 years, including, all cannabis regulations. All cannabis regulations were made prior to 2024 on average. Colorado's was like 2011 and then revised in 2015 and 18. Telluride's is 2011. And so these are municipalities and agencies and states that are coming up with their own laws. And if it got brought to a court, the court would say, well, it's up to them how they interpret it. Not anymore. Now, if it goes to a court, the judge is actually required to interpret that language based on the U.S. Constitution or the state constitution. The actual law that the judge has sworn to uphold is what that needs to be based on from here on out. And so a judge can't just defer and say, well, it's up to them how they interpret it, which is very interesting,
Oh, definitely. Yeah. And so it goes all the way back to the Chevron case in 1984, and it was Chevron USA versus Natural Resource Defense Council, and it was a fight against air pollution rules. And basically, the EPA, the Environmental Protection Agency, wrote its own definition of a word in the Clean Air Act, sanitary or a stationary source, which changed how pollution controls worked for factories. And so, this is a pretty big deal because this is, 1984, the world was a lot different. The Environmental Protection Agency is trying to kind of, protect the environment. But with this vague language, the law was written so vague that, that basically it was deferred to the agencies. And so now, basically what happened is, if the law is clear, follow it. And if it's vague, defer to the agency's reasonable interpretation. That's how it was before. And this has since changed recently.
Mm-hmm. Yeah, and it became the most cited decision in administrative law. And agencies from the DEA to the IRS to state licensing boards started calling the shots. No court oversight. Just bureaucratic authority on autopilot. Like they're creating the regulations, they're creating the laws, and it's not subject to judicial review and interpretation under the Constitution. And so I was just baffled that like that just got overturned June 28th, 2024. Any code can be challenged that any agency has made.
And there's a lot of different agencies out there. Right, exactly. And so, this all changed in June 2024. The Supreme Court in Luper-Bright versus Reinaldo struck it down. A 6-3 decision. I mean, that's pretty substantial. And Chief Justice Roberts wrote that courts must now interpret the law themselves. There's no more deferring to the agency to interpret vague language. And I don't know all the ins and outs, but I think that with the previous kind of way this was interpreted before this Supreme Court ruling, there was probably a lot of lobbying that was going on with these huge mega corporations and these agencies that are supposed to protect, whether it be an FDA for food, whether it be an EPA for the environment. I bet there was a lot of money spent to make sure that this actually didn't change. But guess what? The courts have prevailed and made a big change.
Big change. It's huge. For Alpine, for cannabis businesses anywhere, and for anyone dealing with government overreach. This means that courts can no longer rubber stamp agency interpretations. It also means Alpine's filing with the court cannot continue to be ignored or dismissed. The town's disregard for the court is a real problem in this scenario. And because of this, it's the court's responsibility to rule on the law, and it's the town of Telluride's responsibility to follow it, which they haven't done. Mm-mm. They haven't even responded to the court. The court asked them to, and they got ignored. Mm-hmm. And that's just okay, I guess, but not really.
No. And so now it's no more of just trust us, anything like that, hiding behind ambiguity, wording, vague language. So if the law is unclear, the judge has to figure it out, not the agency. It does not defer back to the agency. This needs to be figured out by the judge, and it's a constitutional matter.
Yeah. Justice Kagan in dissent said it was a jolt to modern government. But maybe that's the point, because unchecked power, that's exactly what's being abused in the Alpine and Telluride case and Colorado case. Unchecked power, regulations that aren't supported by the Constitution and the law, right?
Yeah, right. What does this vague language mean? There has to be some clarity. And so the town of Telluride said that Alpine Wellness was not in compliance, and the MED said that Alpine's motion wasn't timely. But now what the court has to look at is facts and not just nod along. And so this kind of vagueness of we interpret it this way, that's not going to fly anymore. There needs to be clear language. There needs to be clear timelines. And we need to make sure that that's being followed. So it does really circle back to this Alpine case in an interesting way too.
Mm-hmm. Well, I want to talk about this constitutional angle here, forced to confess, because I feel like it's a little crazy, the whole cannabis industry, because from the moment Alpine got its first license in Colorado back in 2011, Alpine had to confess to a federal crime just to operate legally. That's not an exaggeration. To apply on the license form to the state and to apply, you had to establish what you were doing, and you had to prove that you were operating legally with books and this and everything up front, And so, I feel like that's kind of, it's great. It goes all the way back to 2011.
Right. And it's wild because every time Alpine files a local application or a state renewal, they are documenting sales, profits, compliance with cannabis laws, being compliant, but all of it's on paper. And so it's literally a federal drug trafficking confession. It's a catch-22 because you have to act in compliance, but in doing so, you are not able to hold on to your Fifth Amendment right, which prevents you from incriminating yourself. To be in compliance is to be self-incriminating.
Mm-hmm. I mean, one requirement on the application for the state is proof of timely filing of your federal tax return. You have to provide proof that you're filing federal taxes, which they very well know are implicated by 280E, and 280E says you're a criminal drug trafficker. So it's like, in order to apply to the state, you have to prove to the state that you have been cooperating with the federal government and paying taxes under 280E, which is criminal liability. So anyways, it's like really interesting because the Supreme Court already ruled on that kind of thing being unconstitutional way back in 1969. And this is Leary versus United States. We've talked about it a bunch. It's going on right now. This is a modern day version of Leary versus United States. The government tried to make this guy register as a marijuana user to pay federal tax. But if he did, he'd basically be admitting to a crime. And the court said that that did violate his Fifth Amendment right. Crazy. And so it's like all the way back in 1969, we were talking about this. This is a problem. Like in order to have access to marijuana, in order to have the tax stamp, you had to admit to something that was federally illegal. Wild.
Yeah, I mean, it really is. And it's the same deal here. So Alpine had to register as a cannabis business to be legal under state law. But that gave the IRS a roadmap to deny tax deductions and call Alpine a drug trafficker under 280E. And so, yeah, you're legal and illegal depending on which agency you're talking to. And this circles back to the ambiguity that's we're talking about with the Chevron case. It was deferred to agencies, but depending on what agency is being referred to, we're compliant, but we're also federally illegal. We're following codes and rulings and being compliant with a bunch of different actions that need to be taken, from sales tracking, from licensing renewals, a bunch of stuff that comes along with being a cannabis business. But at the same time, it's a violation of the Fifth Amendment right.
Mm-hmm. Yeah. It's like the government's handing you a legal joint with one hand and then handcuffing you with the other hand. And that's a constitutional trap. Like we were told this is a legal pathway. And, so with Leary in the United States, real quick, just to, circle back on this, the Fifth Amendment, no person shall be compelled in any criminal case to be a witness against themselves. Leary versus United States, Supreme Court held that forcing someone to register or provide information that could lead to their prosecution violates the Fifth Amendment. Leary was asked to pay a tax on marijuana, but doing so would have admitted criminal behavior. The parallel here is to get a state and local license, you must disclose marijuana activity. The IRS uses that disclosure to apply 280E, treating you like an illegal drug trafficker. That's the penalty. You're punished for complying exactly what Leary versus the U.S. ruled was unconstitutional. Exactly. Like the parallel is so strong.
Yeah. And it basically the result is now where Norwood saw this federal tax question on a marijuana license renewal as unjust and, a violation, unconstitutional, essentially. Telluride, on the other hand, has decided to weaponize that question. And basically, they're interpreting and creating this vague language and acting like an agency when the state laws do not require that to be the case.
No, they're not in the laws, they're not in the codes, or they're irrelevant. But even, the questions themselves, it's wild. It's just like the fact that cannabis operators were put into a position where complying would create federal criminal exposure. By complying, by filling out the applications, the way the states and the town said to fill them out, created federal criminal penalty. Okay? And now we go back to the Chevron Deference. All right? These cannabis codes were made when a local agency could rule on its own ambiguity. Now they can't do that. This is a good time to dive into all those codes and start challenging parts of them that are unconstitutional and bringing it to the court's attention, because now the court is required to make the determination on whether or not these agencies have violated our rights. You can't send it back to the agency anymore and say, well, it's up to their interpretation. It is not. Now, proceeding 2024, It's now the judge's responsibility to determine if the agencies have formed statutes and codes that are legal. And I feel like that's a very exciting, I mean, I got very excited, you know?
Oh,
and that's
yeah.
for every business. That affects everybody out there, where it's like these agencies can't just push you around without the fear of being challenged in court anymore, and having a judge take a real look at that language. And does that one word really give you the power to do whatever you want and ask you whatever you want, right? Does the government agency's code actually give them the power to get whatever they want in whatever industry you're in? I think it's so fascinating. So fascinating.
Oh, yeah. It opens up a whole slew of possibilities on a whole range of different businesses, because I feel like it gave, prior to this Supreme Court ruling in 2024, it gave the agencies all the power. You know, the EPA, the FDA, the IRS, all these agencies had the power to stretch vague laws and language how they wanted. But now the court has struck that down. The Supreme Court has ruled that no, laws have to be read as written. And here in Telluride, that matters. The town is using vague phrase and language, like any relevant information, to force cannabis businesses into answering federal tax questions that aren't required in state laws. I mean, it's like you said, there's a lot of different ways this can be now applied, because I feel like it's not well known that agencies no longer hold all the power.
Mm-hmm. Yeah. I feel like just specifically, it's like, well, like, why does this matter to the cannabis industry? IRC 280E is vague. What does trafficking mean for a state legal business? Compliance mandates, things like metric software, aren't clearly defined in statute. Tax protest rights, states and towns invent tax rules and say that's how we do it. Licensing games, agencies create obstacles based on policy, not law. I mean, just like in Telluride, it's like, here's some examples of the ambiguity. In default with the IRS, not defined in Telluride's code or state statute. Alpine is in administrative review, not in criminal default. Violation of law. Which law? Federal, state, civil, tax code. Material misstatement. Subjective. Could be a paperwork error or intentional fraud. Big difference. These are all like examples of ambiguity in just Telluride's code. There's a laundry list when it comes to other agencies and all that stuff. It's real important that people pay attention to this right now, because those agencies might not have the ability to push you around like they thought. And now the court can get involved, you know? And so it's like, where does that leave us? You know, we're the town that won't respond, a state that won't acknowledge the filings, and a legal system that finally might be waking up, like as of 2024. And all it is that we need to like spread the word about that, let the people know, like challenge the agencies out there, folks.
Yeah, I mean, that's why
challenge them.
That's why the Supreme Court has ruled on this decision. And so Alpine isn't done. The court and the process behind that, it might be slow, and the town might be silent, but the record is being built, and the silence that they have continued to display, it doesn't stop the truth. We are continuing to uncover and dig so much deeper, and that's what really fires me up.
Mm-hmm. Yeah, it definitely reveals it, you know, and I think we got to keep doing it. We got to keep peeling it open, and I don't know, you know, keep our focus. You know, it's hard to stay focused on this kind of stuff, and there's a lot of things weighing you down, and you know, but to continue to find ways to make progress and keep moving forward is everything right now. And so I hope that that's encouraging to everybody out there.
Oh yeah, and that's why, you know, to all our listeners, we appreciate you, but keep paying attention, keep supporting us, keep the discussion going. The conversation behind this, I feel like, has been non-existent prior to us trying to bring these things to light. Like, I didn't know these agencies had so much power, and now just a year ago this was overturned. It's pretty wild. So this isn't just about cannabis. It's about what happens when a government stops responding, and when the Supreme Court has made filings that need to be brought to light. It needs to become public discussion.
Mm-hmm. Yeah. I mean, what happens when you don't let them get away with it, guys? What happens when you push back and you don't just tuck your tail and under the notion of do what we say or we're going to chain your door off? Are you allowed to do that? Are you allowed to do that? Are you allowed to say, do what I say, give me what we want, or we will seize your property? Right?
That does not sound legal.
We got to take the power back.
Yeah.
You know what I mean?
Yeah.
And there's ways to do it. And we're going to keep doing it. Keep breaking the cipher, all right?
Oh, yeah.
That's what we got to do.
Well, here we are. Episode 7 is going to be coming. Stay tuned. Stay loud. Stay legal. Stay healthy.
Mm-hmm. Yeah, make sure you follow us, please, on Facebook, Instagram, X, YouTube, Apple, Spotify. We need all the support we can get. We have our thermometer for our $100,000 fundraiser here at Break the Cypher is still at 0. And we just wanted to let you know that we're not giving up, and neither are you. And we appreciate you for that. Like, eventually, you're gonna be like, "All right, here's $1, fellas," And you can find that link on our donation page. We take Bitcoin, and we have a Venmo thing right there that you can just scan or whatever. And but if you have a little extra Skrilla for your boys, we'll use it to keep doing this and to keep expanding and to help out with our bills and all the fun things that come with doing a podcast. So,
and let us know, if you want to see some fundraiser action, if you want us to do a little virtual car wash, get all sudsy and get some music going. Like, we'll do a little live stream for you. We'll get a little donation virtual situation happening.
Yeah, I'll do that. I'm totally in. And if you can't support us in that way, you can support us in other ways, just by following, maybe liking our posts, commenting a little bit. We need good engagement with you guys, and we're excited to do it. Maybe you are a lawyer. Maybe you are an accountant. Maybe you have this or that you could offer, and you want to connect with us. Please do. Reach out at admin@breakthecipher.com. That's all I got to do. And our website is breakthecipher.com. And so, without further ado, you got anything else, my dude?
No, man. I'm just thinking about that fundraiser now.
Yeah. Down at the car wash. At the car wash. Maze at the car wash. All right, y'all. This has been Break the Cypher. Peace.
Peace out.